Hi there, you're watching BloombergQuint, and this is the fine print. After 4 years of a tedious wait, India is hopefully just a step away from getting a privacy law. The 30-member Joint Parliamentary Committee supported its report and a draft data protection bill last week. This bill is likely to become the basis of law that's meant to lay down privacy standards when citizens' data is collected by state and non-state actors. To understand how meaningful and practical these safeguards are in the JPC's version of the law, I'm joined by Vrinda Bhandari and Rahul Matthan. Vrinda, Rahul, welcome to the fine print. As we discussed offline, the attempt of this conversation is to look at the bill both from the concerns that are pertinent from a civil society's point of view and a business point of view. So I'd like your expertise on both these sort of areas that we are sort of hoping to cover in this conversation. Vrinda, I'll start with you first with a slightly more macro view of the bill. And when you look at the architecture that the JPC has proposed of the bill, um, from the conversation, it seemed that the third or the fourth line started ringing alarm bells in your head. Could you weigh in on what about the architecture in the shape and form it's come out of the JPC bothers you?
Yeah, thanks a lot, Paismi. Really wonderful to be here and to be, again, a co-panelist with Rahul as always. So I think from a macro perspective, the one thing that does kind of concern me is the pivot towards rising state powers. So as many parliamentarians have mentioned in their dissent, it seems that there are two regimes. There's one regime that will apply to companies, and then there's a regime of exceptionalism that will apply to the state. And you kind of see that already in the long title. So the long title of any act is to explain to the public what is the purpose of the act, right? So for instance, the bill starts with like to provide for the protection of digital privacy. However, the JPC actually makes an amendment where they specifically insert the words that one of the objectives of the bill is to ensure the security and interest of the state. So to ensure the interest and security of the state. So, I mean, to have a national security concern that's read into the very long title or preamble of the act is concerning because the objective of a data protection law is not national security. The objective of a data protection law should always be grounded on the autonomy and choice of the individual and protecting their privacy. So I think the long title reflects some of the JPC's amendments and the bill itself, which seems to have a separate regime for the state, which seems to create a lot of exceptions for the state. So I think that's my macro takeaway. And then we can go into the specific provisions of the bill that are concerning.
Sure. In fact, when I was reading, I went back and checked Justice Sri Krishna committee report, Vrinda, and there, as they were approaching to sort of draft a report or the law, that committee had itself sort of distinguished how the US and the UK, or rather the EU, in their respective data protection bills, or rather laws, had a different approach compared to China, and it seems like what the architecture is currently seems to be a little like China, where again security concerns are deeply embedded in their framework as well. Rahul, come in here. How are you looking at it from a big picture point of view? The bill that has come out from the JPC.
So first of all, it's great to be back, and it's great to be back with Vrinda again. You started out by saying that we are just one step away from having a privacy.
I said hopefully. I caveated it very clearly with saying hopefully, Rahul. But go on, please.
I just wanted to say that I have felt that we are one step away for the last decade. So if we can get there, I would be more happy than anyone else. And I think it's really important that we pass the law. This is not perfect. No law will ever be perfect. And all the things that I am saying, I don't want to speak for Vrinda, but all the things that I am saying is just in terms of, look, there are things that are not perfect, and can we make them better? I would say that 80 to 90% of the law is good. It is based on GDPR. It is based on the world standard of data protection. There are some things that in my head are slightly misaligned. Vrinda addressed the security piece. I think we can get into that in a little more detail later. But from a macro perspective, one of the big things that leap out to me is that in this draft, for the first time, we've conflated personal data with non-personal data. And so the title, once again, going back to things as fundamental as the title, has been changed from the Personal Data Protection Bill to the Data Protection Bill. And the applicability of the law has been expanded to include, in addition to personal data, non-personal data as well. And in many places in the law, the term personal data has been replaced by the term data to signify that it extends not just to personal data, but to non-personal data. Why is this a concern? Ultimately,
I'll just come to you in 2 seconds, Rahul, on the concern bit, but I'll just, for the benefit of our viewers, state what the JPC has suggested. They've suggested we include the non-personal data within the ambit of the law. It is defined as any data which is not personal data, and it has also suggested reporting of all non-personal data breaches. Rahul, with that, back to you in terms of the consequences this could lead to.
Yeah, and let's just take those two things that you said, right? So the definition of non-personal data is all data which is not personal data, and if the definition of personal data is that which can be identifiable, then essentially you've got every type of data covered under this law. It becomes the most powerful regime that exists, and since no other country in the world does it, it is the most powerful regime on the planet that relates to data. And I don't have an objection with it being powerful. I'm just trying to talk about some of the nuances. When companies want to work with personal data, one of the things that we recommend that they do as a good practice in order to ensure that the data remains secure is to anonymize it. We say that if you can, as soon as possible, anonymize your data, what you're doing is, in the event of a data breach, what gets leaked out is information that cannot be identified with an individual, and therefore that individual has got some measure of protection against the harms that could occur. If you say that even if you anonymize your data, your personal data, you still are covered by the purview of this law, and that you still have to report the breaches of that data, it removes the incentive for companies. I wouldn't say it disincentivizes companies, but certainly that tacit incentive that was contained in the 2018 version as well as the 2019 version, and quite frankly, every other data protection law in the country has gone. And while this will not off of itself stop people from anonymizing, I think that we need to think about the consequences of this. The second implication of this is, if we're saying that we need to report non-personal data breaches, who do we report it to? One of the reasons why you report a personal data breach is so that the persons affected could actually take measures to change their credentials, or very often we reuse our passwords. So if one site has been breached, then you know that if I reuse that password in 20 sites, I'm exposed in all those places. These are all really important reasons why you do notification. Non-personal data, by its definition, cannot be identified to an individual. And if that is the case, what is the purpose of providing this notification other than to secure your data systems? And if you wanted to secure your data systems, then the Personal Data Protection Law already had security features in it as one of the privacy principles. So I think that maybe as you said, the Joint Parliamentary Committee wants to bring all data under the purview of this regulator. I think I'm not one who's in favor of a proliferation of regulators. So from that perspective, I can see that it makes some sense. But if you see all the other consequences of doing this, it is actually doing more harm than good.
Yeah. And I'd just add to that, and we can again go into it sort of in more detail. Sure. But I think just two things to what Rahul pointed out is, even if you actually see the clause which deals with the reporting of breaches, it is very vaguely worded, and it seems like, so they changed the title of the clause to say it deals with the reporting of breaches, but not personal data breaches. But if you actually see the provisions, they sort of have not removed the word personal data in many of the sub-clauses. So it is also very confusing as to how this would actually work. And so the whole structure of what this means for companies, even from a compliance perspective, I think is unclear. And to the point about regulators, I think it is worth discussing, or at least keeping in mind that the DPA then is really going to become the most powerful regulator in India. As Rahul pointed out, no other
inundated. Also, Vrinda and Rahul, inundated with all sorts of complaints, right?
Absolutely.
Yes, absolutely. Inundated with complaints. We don't know whether they're going to have the strength, the performance of previous tribunals. When you look at the number of complaints that they're going to get, whether they're going to have regional officers, who's going to decide the funding. So, you have questions of independence, working, power. all of and discretion, like the discretion and the manner in which that power is exercised, all become really important to consider. So yeah, I think that is something we should at least keep in mind when we're talking about what it means for this for this law to have like personal data and non-personal data. Remember, neither GDPR nor California nor Singapore, none of these countries have a data protection law. They all have a personal data protection law.
And also, I think some of these implications are sort of being discussed or coming only now, given that this suggestion came out of the blue. We had the Krish Gopalan committee set up to look at how non-personal data can be harnessed for the betterment of, let's say, some of the systems, whether it's financial, medical, etc. But this has come out of the blue. So some of the consequences and even implications, all of us are grappling with it. Vrinda, the second big concern, and it sort of ties into your concern with the objective of the law, it's been articulated to protect the interest and security of the state. It's sort of it's a point that has been discussed, and sort of civil society members like yourself and activists have hugely discouraged, I think, even in their sort of conversations with the JPC committee, that there are just too much rope that has been given to the government to sort of collect and process data and exempt any of its agencies from the purview of the bill. So this is something that was there in the Personal Data Protection Bill of 2019 as well. So that's clause 35, but now there is a clause 36 which has expanded the scope of this exemption for a variety of purposes. For instance, processing of personal data for investigations, disclosures in order to enforce a legal right or claim, processing for judicial and journalistic functions, etc. How will it play out in the practical world?
Yeah, so just to clarify, so the second clause that you're talking about, clause 36, was also there in the 2019 version. And versions of this also existed in the Sri Krishna Committee report, although I think they were different in pretty important ways. So there are two clauses that you mentioned, right? 35 and 36. And I'll start with a bit, and then Rahul can join in on his critiques as well. So what is clause 35? So it's an exemption provision. So the central government is permitted to exempt any agency of the government, so any government agency, from the application of the entire act. So this is very important. You're talking about exemption from like the obligations of fair processing, reasonable processing, security safeguards, purpose limitation, anything, as long as the government believes it is necessary or expedient in the interests of national security, public order, security of state, sovereign relations, etc. Now, this is important again for two reasons. So here you say necessity or expedient. The Puttaswamy standard and the privacy judgment really talk about the importance of proportionality and necessity. So what does it mean when you say something is necessary? My fundamental rights can only be restricted if there is no other less restrictive alternative. So if this was the only measure for achieving a certain goal, then the government justifies or fulfills the necessity prong of these tests. But when you have the word necessary or expedient, expedience is just convenience, right? So if it is convenient for the government in the interest of national security or public order, we all know that public order is a term that's very hard to define. According to Supreme Court's jurisprudence, it's not law and order, it's a higher threshold, but often we see it being used as a pure law and order purpose. So the power of the court, the power that the government has, is unparalleled compared to other jurisdictions. Every country has some national security exemptions, but I think the manner in which these exemptions have been incorporated is problematic. And then there are two changes that the JPC made. So the JPC first said that they added a non-obstante clause, which essentially just says that notwithstanding any other provision in any other law. Now, my worry is that what does this mean with the RTI Act, right? So if you see the dissent note of Jairam Ramesh, he actually mentions that I would have at least agreed with your proposal had you said that these government orders have to be placed before Parliament, so that there is some parliamentary oversight. But obviously that recommendation was not accepted. So given that, and given that there is a non-obstante clause, I'm not clear whether the RTI Act will effectively be will become infructuous because they will just cite a national security exemption. Will we ever come to know what are the government orders that are being passed? How many government orders are being passed? Will they be published? The answer to all of that seems to be no. And the second change that the JPC makes is that they say that the procedure which has to be followed by the government agency must be just, fair, reasonable, and proportionate. What this kind of focuses on, it limits it this proportionality application only to the procedure, but not to the substantive invocation of the exemption. So to put it kind of simply, the government doesn't need to establish that the exemption from the entire data protection bill is necessary or proportionate to achieving its interest of national security. They can simply state that, and that's enough. So these are some of the concerns that are there with 35. And Rahul, do you want to start with 36, and then I can
yeah, no, absolutely. So look, I mean,
no, and before Rahul, you start, also I'd like both of you to articulate that this language is all beautiful and the technical sort of assessment that you're doing of it, but it would also help if you could give practical examples that, you know, could infringe right of privacy in a very disproportionate fashion. Rahul, back to you.
Yeah. So look, I mean, I think the simple point that I had, and 35, I have not seen in too many data protection laws around the world, but 36 I have, right? So every data protection law has got some sort of a regime which allows law enforcement access and provides exemptions for that. What's interesting to me is I've studied this from Justice Sri Krishna's version in the 2018 draft, the 2019 draft, and now this. And it's evolved in a really interesting way. Maybe it's interesting only for lawyers, but I'm going to share it with you anyway, right? So essentially, the 2018 draft allowed for exception, but said that regardless of the exception, all the provisions of chapters 2 to 7, etc., will be exempted, except the provision which said that you need to process information in a fair and reasonable manner. Right, and so there was the exception, which actually operated in a manner that even though you're exempting everything, you still have to be fair about the way in which you operate. The next version of this in the 2019 draft, that version essentially came up and said, replace the fair and reasonable with for a specified purpose. So at least, fair and reasonable, I think, was a high threshold. But now with a reasonable purpose, at least we still have some threshold. You can't just use it willy-nilly. But in the latest draft, everything has been removed. Chapters 2 to 7 have been exempted. And the difference between the two is that unlike 35, which an additional step has to be taken. As far as 36 is concerned, 36 applies, that's an exemption that applies right now. Which means there's no further action that needs to be taken by notification or identification of any authorities or any such thing. So I think, Vrinda deals with this on a more regular basis, but this also means that this applies to police officers and law enforcement, right? And so maybe the larger agencies, it's easier to handle. They have more processes in place, but we know that law enforcement acts in a very different way. And so there, in a sense, the new version of 36 without fetters, without restrictions, is a little concerning in a practical sense.
Vrinda, you want to articulate the concern? So 35, I think broadly now, because it's been debated to death that, it gives too much power to government to exempt its enforcement agencies. Can you give us some illustrations on how 36 can manifest in arbitrary ways?
Yeah, so 36 actually is very interesting because if you see 35 very clearly says that the central government has to be satisfied that it is necessary or expedient, right? So this is an order that has to be passed by the central government. 36 does not have any such language about who can invoke the exemption. 36 just says the provisions of chapters 2 to 7 shall not apply when, except section 24, which is security safeguards, shall not apply where personal data is processed in the interest of prevention, detection, investigation, or prosecution of any offense, any contravention of law for the time being in force. So this means not just your local police station. So if you look at what are government agencies under 35, you'd think about IB, CBI, RAW, NCB, Narcotics Control Bureau, ED. But 36 is going to be your local police station, which is going to be investigating any complaint. It can also be your RWA, because it doesn't specifically say that only governments are entitled to this exception. Your RWA tomorrow, and we all know, we've all seen during the pandemic that RWAs have often become mini sovereigns in themselves in terms of the CCTV cameras and facial recognition and biometric recognition and those MyGate passes, etc. What this essentially means is you can just justify any processing of personal data and not complying with any collection limitation principle. So this means technically under the law, and my RWA can say that, there's a concern for rising security, there's a rise in crime. So, we want to prevent any offenses. So we are not going to have CCTV cameras everywhere. we have no way they can then collect any information within this, because they don't have to comply with any collection limitation. They can share this information with whoever they want, because there is no, again, limitation on that. They can even share it with law enforcement purposes. They can use it for other commercial purposes. They can, decide who's coming in, what car are they coming in. They can really do a lot of targeting around that. They could potentially even sell that data to third parties. I mean, I think that would even hopefully be a stretch under this provision. But I think the point is that all of this is completely unregulated, because who is going to be able to check? All an RWA will have to say is that I'm doing it for national security purposes. I don't have to, there is no parliamentary oversight. There is no judicial oversight. So there is nobody who is authorizing this decision or who is reviewing this decision to say that this is fair. And in many cases, people may not even come to know. I mean, what if there's actually not even an obligation to publish the order. So, at least if you look at like surveillance orders, etc., like, Telegraph Act, IT Act, at least all of them say by a written order with reasons to be recorded in writing. So even that kind of minimum language is not there right now in 36.
Okay. Hopefully, with all of this conversation around the final version that we'd see from the government, this would get rectified. I'll move on now to some of the business concerns, one of which Rahul already pointed out, which is the inclusion of non-personal data, which can become a nightmare for businesses. Rahul, the second sort of big concern for you was how data fiduciaries, or those entities who collect children's data, the provisions related to them. The JPC has suggested that data fiduciaries cannot profile, track, monitor, engage in targeted advertising that causes significant harm to children. They've also said that specific data fiduciaries which are involved in processing children's data or providing services to them will be classified as significant data fiduciaries. In the practical commercial world, what could this translate into?
So the first thing I'd like to say is that the provisions with regard to children's data has actually marginally improved, in the sense that it earlier had some strange language which said that you must only process the data in the best interests of the child, almost imposing on data fiduciaries, which are just collectors of information, some obligation to understand what the best interests of the child are and then process in that manner. That's been changed now to protect the rights of the child, which, in a sense makes it easier for businesses to understand what it is that they have to do. But having said that, there are a few provisions that have been in the draft from the beginning, that have been worrisome from the beginning and still remain. I think one is this age verification requirement, the fact that any data fiduciary who is a significant data fiduciary now needs to ensure that, first identify the children and put in place measures to understand that, when you are signing in as someone who is above the age of 18, and therefore there's a different set of rules which apply to you. Whereas if you are someone who's under 18, a whole different set of rules will apply. And somehow factor that into the internet, which right now just doesn't work in that manner, right? There's no, you don't have to submit your Aadhaar every time you log on to the internet. But there's no other way in which to do age verification in the aggressive manner in which it is drafted in the law. To be clear, there are restrictions on processing of children's data in every regulation. But this age verification mechanism is only, to the best of my knowledge, there in the Indian context. It also applies to all significant data fiduciaries, regardless of whether their business is oriented towards children. And I can understand if you're talking about people who make children's toys, or people who have websites that provide children with entertainment or education, and if you make them subject to a higher threshold. But there are many sites, encyclopedias, for example, that children use just as much as adults use, and they're not oriented towards children, but now they are subject to that higher threshold. How they're going to comply with it is something which I don't fully understand how we will practically do this. So I think there is the age of the child, which is something that we've debated at length. I think to use the age of majority, which is essentially the age of consent. So in legal parlance, that is the age at which you're deemed to know enough to be able to take decisions that could affect you, as opposed to the age of using the internet or using technology, which is not that. I mean, there are people, children today, and come on, we've been through the pandemic for 2 years. Vrinda doesn't yet have a child going to school, but I've had children going to online Zoom school, and they use, these are not and apart from the inconvenience of having to go and sign in every time you need new consent for some new thing, there are many things that children, teenagers who are, say, between the age of 16 and 18, who actually need to do on their own in the internet without the parent having to consent to those things. And that's an important thing to consider when so much of our lives have in the last 2 years and will continue to be digital.
Okay, so
in fact, can I just add?
I just come to you in
okay.
Rahul's utopian world. All kids are going to encyclopedia websites, so I don't know which. So, but tell me this: there is Instagram, there is social media platforms that I think I don't even know about, which kids regularly access and have profiles, and so they're not targeted to children. So, is it just that we have put in something in the law, or rather we are proposing to put in something in law that's not at all practicable, Vrinda?
I mean, I think the point is, how will any of this work? Because the age of consent in all of the other countries and these apps work is either 13 years or 16 years, right? And so now they're going to have specific India-based regulations. And all of them are really either, like Rahul said, they're going to have hard identifiers where you're actually providing them personal data, which is the last thing you want to do to a corporate entity. Or they are going to say that, oh, we agree, by reading these terms of conditions, you have deemed to be a major, or you have gotten the consent of your parent, in which case the consent is actually effectively meaningless, right? Because nobody's actually going and checking with their parents, like, are you checking my Instagram account, etc. So I think, that is going to be a real problem. I mean, and the two other points that I want to point out, I think Rahul touched upon one thing when he said, the need for privacy for children, like where your parents don't necessarily know what you're doing online. I actually think this bill has made a sort of taken a step back, because the 2019 version at least said specifically in the law that if you're providing counseling or child protection services to a child, you do not need the consent of your parent. And I think that is essential. I mean, we've seen problems of mental health, rise during the pandemic, especially amongst teenagers. And now what the JPC has done is they've said that, oh, this will be specified by regulations. And I think this was actually a statutory safeguard that should have been there. That if you're providing counseling services, child protection services, you're dealing with child sexual abuse cases, like all of those things should have certain exceptions, because in many cases, the perpetrator may be somebody in the family. So I think that's one way where we've gone bad. And the second point is the thing that Rahul mentioned, that the obligation to monitor, the prohibition against monitoring rather. What does this mean in practical terms for, like, imagine a school, like your report card is a monitoring report card, right? Like, what is your report card? It tells you your academic performance over the year, whether you had disciplinary records or whether you've achieved any awards. That is a clear profile or a tracking of an individual. Or when you're applying for any of these, when you're applying for any competitive exams, the tests that you do in 11th or 12th, so your JEE preparation, your CLAT preparation, all of those have a track of, how have you done previously? What are the kinds of, what level are you at? What kind of papers do you want to do? So, I mean, I just think in practice, how is this going to work is really going to be difficult to understand.
So, sorry, to understand all of the examples, Rahul, that Vrinda gave, is the committees, or rather the JPC, saying that you can't do all of this now, or you can't put, let's say, identifiers against an individual to even track education process or level progress? Is that what the committee is suggesting?
I mean, look, when you frame it like that, no, the committee is not actually saying you shall not track children who are doing exams. But what's the effect of the language? If you are doing an online examination, or if you're doing online testing, and please, let's say there's one thing that this pandemic has done, it is that it's democratized education. And so there are people who can get education that otherwise perhaps couldn't. Of course, there's the access to the internet and all of those other problems, but it's made it possible. And the really smart educational tools actually will orient the teaching so that based on the assessments that they do, they will say you need a little more help in this area, but not so much help in that area. And so they will modify the teaching plan on an ongoing basis. This would be an ideal form of education, even if it's done in an online manner. That can't be done. Very clearly, that can't be done for children, because the regulation says you cannot monitor, track, or behaviorally
profile, track, behavioral monitor.
No, I think we're in a sense cutting ourselves off at the feet, because we have these tools that are proven to provide better educational outcomes, but we're not allowed to use them because there are other things that can be misused. Because I still agree that significant data fiduciaries, or quite frankly anyone, should not be allowed to target advertisements to children. And there's a whole bunch of things that they should not be allowed to do. But because we have used broad language, or perhaps because we have not thought through the other consequences of what this language could prohibit, we're ending up in a situation where all of these things can't happen. So don't get. I'm quite sure Vrinda agrees with this. There are a lot of additional precautions and care that we need to take with regard to children on the internet. But while we do that, we've got to be really careful to ensure that the benefits that they get out of this aren't forestalled. And I think that by putting the age at 18, which is way too high, there is no country in the world that has 18, at least that I know of off the top of my head. And with this sort of excessive regulation as to what can and can't be done, which is focused on the action as opposed to the outcome. I think if we focus on the outcome, we have a much more sensible regulatory approach.
Sorry, Rahul, why would you say it's only for online learning? I wouldn't read the regulation as only directed at online learning. It would apply to even offline learning.
Yeah, well, I mean...
because the law doesn't, if you see the clause, it nowhere really says that like the data fiduciary providing online services. Why would this not apply to a school?
Yeah, you may be right. And the word data actually includes just any sort of data. So
because
I really hope that we are not getting to the point where the data protection law, which in my mind is a law that is used to regulate data in the online space, where this sort of profiling and monitoring can actually happen on an automated basis. But you're right. I mean, with the language as broad as it is, it could well also apply to just the physical records of a child in a school. I almost didn't. I want you to take that back, because if this gives people ideas, that's a very, very slippery slope that they're going down.
I would hope that it's not interpreted like that. I think my concern is that the way you want a law that is clear, that's not open to this kind of ambiguity, where we say this is obviously the purpose of the law. This is, and we still are not very clear what the purpose of the law in that sense is. So, my worry really with all of these provisions is they could have just been a lot more clear. And so that's that was my concern.
More sort of to dwell upon that, hey, look, we want to prevent these outcomes, rather than lay down that you can or cannot do ABC. Okay, so a bunch of unintended consequences for data fiduciaries who are handling children's data, or are even in the offline world providing education, etc. The final point, Vrinda, that I want to come to you with is also exemptions for employers. There also the committee has proposed that personal data can be processed by employers for either hiring or termination, if you're providing any service or benefit, verifying attendance or assessment of performance. I was always very bothered by sort of employers asking for biometric. So I think that sensitive personal data is out of the window, or out of the ambit of data that can be collected by employers, right?
Yes, yeah. Sensitive personal data is not included at all. So you can't have biometric attendance, at least on paper. Obviously, it's a different issue what individual employment relationships are. The only change that the JPC makes is that they basically make it clear that any such personal data cannot be processed for like these recruitment, attendance, performance orientation purposes, if such processing is necessary, which was the old standard. And they've added or can reasonably be expected by the data principle. And there's although the language of the JPC seems to suggest that they are recognizing the asymmetry in relationships between employers and employees, and they want to protect employees. I think that the use of word or should probably have been and in terms of actually if you want to give additional protection. So I'm not sure on that usage. And I think, one of the points Rahul has mentioned, and so maybe Rahul, you want to elaborate on this, which is that you've actually excluded one really important part of why would employers want to use data? So, I don't know, Rahul, if you want
it's not excluded as much as it hasn't been specified.
Specifically,
One of the things that most employers want is to be able to carry out investigations on employees that are, for instance, committing some sort of fraud inside the company, or doing espionage or stealing money, or just any of those things. And the in order to do that, you'll need to collect personal information that's contained in emails and things like that. And if you have to collect, if there is an obligation to obtain consent before you collect any personal information, I don't know any employee who's going to consent when they've actually stolen information from the company and that incriminating evidence is in their emails. If the company goes and asks them, I'd like your permission to look at your emails, no one's going to give them the permission, right? So around the world, this the exemption for employees is also extended to these sorts of reasonable investigations, where you're actually looking at the information because the person is under suspicion of having done something. At that point in time, you don't need to collect consent. And this
Sorry, Rahul, just very quickly, if you would explain to us jurisdictions who have done this. So let's say the intent is to find out if I've committed fraud or breached or taken data, proprietary data from my company and sold it to a competitor. But and if you're seeking my consent to read my emails, it's a suspicion to begin with, but you're going in it deep dive, and which you may not even find anything. So there are other safeguards from the employee's point of view in this sort of exercise that the employers can carry out.
To be completely clear, this doesn't apply to your personal Gmail or any of those things. This applies to company-issued email. Typically, on company-issued email, you must only do your company-related work. This does not extend to getting some sort of subpoena to get into your personal emails. For that you need the court. You need the law enforcement agencies who have the authority to do that. But in some jurisdictions, and to be clear, there are many jurisdictions that actually don't allow this, and so it is a problem. And I'm speaking from personal experience of having handled some of these investigations where many countries have been asked, how does it work? I know there are many countries where you are not allowed to look at an employee's official email either without their consent. And so you have to go through a whole bunch of hoops. Look, everything can be sorted out. The way you sort this out is that when you sign up your employment agreement, you say that I agree to allow you to look at my email. You've got consent up front, and at any point in time, it can be used. So everything that we've spoken about can be sorted out. Age verification can be sorted out.
But you don't want those kind of blanket sort of consent forms.
You don't want that kind of blanket consent. You don't want to have a different type of internet where you have to show up, you provide your age every time you sign up. So look, everything can be done. It can be done with greater inconvenience. It can be done at a larger cost. And we have to evaluate whether it is worth it, this thing that we're asking people to do.
Okay. My final point, Rahul, again to you, is some concerns that you had on the data protection officer now being suggested by the JPC to being a key managerial key managerial personnel needs to be the DPO. Again, what's the big deal?
Look, I mean, the data protection officer is an important role, and that is the first line of defense that any individual has, right? Even though the DPO is employed by the company, it's the person to whom the consumers of that company come with their complaints, and they have to address it. It's not a small job. It's a job that will, as data protection becomes important, become a more than a full-time job. You'll need to have a DPO's office. Many big companies have a DPO's office. Now, I think we've had this nodal officer in various different legislations. And we've found that companies have just appointed some low-level flunky to be the nodal officer. Sometimes even outsourced it to someone who's not an employee. And I think the JPC has seen that, and maybe the ministry has told them that we're having this problem. So they say, let's make it a senior person. So now they've not only just made it a senior person, they made it the C-suite. The people named are CEO, CFO, company secretary of the company providing the service. So now the CEO of the company or the CFO who's got a full-time job, and if it's a large company, it's got more than a full-time job, has also got to do the data processing officer's roles. That's not enough. I think if you look at the applicability of the law, large global corporations that have significant consumer base in India will also have to designate their C-suite as the DPO of that company in India, which means that they have to come and be resident in India, which seems completely an overstretch. I know we're a big and important country, and we've got a large population of technology users. But to ask global CEOs to relocate to India in order to comply with the DPO obligation is a bit of a stretch. I'm quite sure that when the Data Protection Authority comes out, there's going to be some rationalization of it, because there is a provision which says, or any other such person as may be prescribed. I'm sure that they're going to allow, say, the CEO of the Indian subsidiary or something like that. But in the current language, that is not clear. And until then, there's going to be some uncertainty as far as companies are concerned.
You would
Get
hope
more
they would
talent via
rely.
the-
You would hope that they would rely on the word manager and interpret that sort of more liberally.
Once again, manager of the
I
parent
mean, because they've not
company.
mentioned, they've said, CEO manager. So you'd hope that what is manager would be interpreted sort of more liberally till some clarifications come.
Vrinda, sometimes you're very optimistic, but most of the time you're very pessimistic. So
Okay, guys. We're completely out of time now. For a quick sort of recap for our viewers on concerns that have been articulated by Vrinda and Rahul in this conversation. Vrinda mentioned that we've added state security and interest in the preamble of the law itself. The exemptions that are provided from the law have been sort of widened. That's another concern. The third concern that Rahul mentioned is with regards to data principles that handle children's data. And fourth is the relationship between the employer and employee. And of course, I'm calling it the Zuckerberg problem, because in Rahul's interpretation, Mark Zuckerberg can be asked to be a DPO. Guys, final thoughts on where do we go from here? Does some of the concerns that you've articulated and many experts have articulated in the course of last week, does the government assess them, maybe sort of plugs the loopholes, makes it more watertight, and then maybe comes with a version that is more sort of solid and let's say amenable to both the businesses and civil society? Where do we go from here?
I mean, I think I don't expect much change now from this version. Like, there was this whole 2-year period when the JPC was meeting where none of these concerns we've expressed are new, right? Like, these concerns have been expressed. Some of the changes that they made, which are new, like non-personal data, etc., you would hope that there would be some kind of dialogue. I'm not that hopeful. Having said that, I do think, despite some very problematic provisions, which I think will be challenged in court, I do think it's important to have a data protection law. I mean, I do think it's important that we now finally come to a stage where we have a data protection law, because it really has been too long. And once you get the law, you can hopefully amend it. There'll be maybe some court decisions, but the point is we need a law, because there are many provisions of the law which actually provide really important protection to an average citizen. So I think it's really important to have a law. Obviously, it should be a much better version of this law, but I mean, I think it's important that we pass something.
Yeah, it needs to be passed. And of course, don't miss Vrinda's slide in that a lot of these provisions might be susceptible to court challenge. Rahul, final word to you on how soon do you see this come alive?
Yeah, so once again, if there are any changes, as Vrinda says, then obviously we've got to factor the time that it will take to make those changes. But if not, as you said, we are one step closer. I don't think there's anything left bar the debate in Parliament, and then the political will to actually take it across the line with a vote, and then, of course, notification and presidential assent. Just to echo what Vrinda said, I have been waiting for this for 10 years. I don't think I can wait for another year. We need this law. It's really important for many things that we're doing. I think more importantly, we need a regulator. Because we've already seen the CCI is starting to say that privacy is a non-price factor of competition. And we're seeing the consumer protection regulator coming up with some privacy-related regulations. That's not ideal. In fact, that is something that we should strongly resist, because this is a specialized area. And so you need a regulator that is equipped to deal with these sorts of issues in a sensible privacy-focused manner to then coordinate with all of those regulators. I'm not saying that it's not a factor for competition, but we need that. We need that, and that's not going to happen without the law. So if there's anything that I think we should really try and fix, it's the non-personal data thing, because it throws a spanner in a whole bunch of works. But short of that, I think everything else can be fixed if we've got a good and competent data protection authority who will be able to provide clarification on many of the issues that we've even discussed today. I think there's a lot of room for them to do that. So let's get on with it, is my fervent wish.
All right. On that optimistic note, Vrinda, Rahul, many thanks for articulating some of the concerns and some of the pluses that have come out of this exercise that has been going on for the last 4 years. And hopefully, we will have a law soon that will, in a very, let's say, that will address some of the concerns that both of you have sort of articulated. And as the government gives the final shape and form and color to this law, hopefully the practical authority, which is the Data Protection Authority that is going to implement it, will also start to take shape. Thank you very much for joining us here on the Fine Print, and thank you so much for watching.
Thank you.
Thank you.